Okay, let's go on the record on cause number DC 207610. Council, make your appearances.
Amanda Swartz for plaintiffs.
Gregory Shamoon representing Stonecoat of DFW LLC.
Honor David Kane for DK International, third-party defendant.
There are other people here. Are they going to make announcements or not?
Yes, this is Favad Bajaria. I'm plaintiff's counsel. Amanda Schwartz will be representing plaintiff at this hearing.
Welcome to Zoom. Enter your meeting ID followed by pound.
I don't know who's doing that exactly. I think okay, you don't need to do that, Mr. Lipscomb. Mr. Lipscomb, you don't need to do that.
Enter your participant ID followed by pound. Otherwise, just press pound to continue.
But Mr. Lipscomb, you're already
You
connected.
are in the meeting now. There are 19 participants in the meeting.
Mr. Lipscomb, can you hear us, sir?
I can now. Sorry about that. I was having computer audio issues, so now I'm in on computer video, telephone audio. So sorry about that.
All right. Let's go ahead and proceed.
Judge Gregory Shamoon, if it please the court, Stonecoat of DFW LLC moves for traditional and no evidence motion for summary judgment as it relates to plaintiff's claims, Ray Austin Holdings LLC. This lawsuit was filed on June the 2nd.
Your Honor, may I really quickly? I apologize for interrupting. We do have a motion for continuance of the MSJ hearings. I filed one and Whitmore's already filed one. I, however, could not get it set at this time because Mr. Shamoon would not allow us to set it. But those have both been on file.
Well, hang on.
Continuance of this hearing or a different hearing?
This hearing and yeah, so Whitmore and I both filed continuances for this hearing. In order to have it set at this time, we had to have permission from Stonecoat's counsel, and they would not give us permission to set it at this time. So we couldn't actually get it set, but they are filed with the court. Both Mr. Garrison and I filed one.
Well, I don't set hearings for any court, Your Honor, and I don't give permissions to set hearings, and I don't have a hearing date set on anything other than my motion for summary judgment.
Ms. Schwartz, let me just say this. That's not normally how it's done, but we just got new clerks assigned to us again. Thank you, District Clerk. And so did they tell you needed to get permission from Mr. Shamoon? That's not the normal.
They did, and in fact, Your Honor, I just called because DK has another MSJ hearing on next Monday to ask permission to, because I called the court and they said you need permission of the third party to set it during their time. So they did give permission. So I'm just about to file the notice of hearing for the continuance and the motion to reopen discovery for next Monday. But we were not able to get the continuance on the motion for summary judgment set for this time.
That's if the clerks told you that was a mistake. You did not need Mr. Shamoon's. As much as I respect Mr. Shamoon, he's not the judge here. So
yeah, I've never had that before, but they said without permission they wouldn't set it. I tried.
Let's deal with the continuance issue first, and then we can talk about that, and then we'll go to the actual motion. So what's the continuance issue?
Your Honor, we were before you a couple of weeks ago on a scheduling conference. This case was filed in 2000. And what happened was, as in most construction cases, there were parties added after the initial party. When the original case was filed, the court automatically sent out a trial notice for November of 2021. So by the time that the third parties were added, there was only 4 months left in the discovery period. So Stonecoat has said they're not going to answer any discovery and they're not going to participate in discovery, and they want to have this MSJ heard. The reason for the scheduling conference was they've held up discovery for everybody. We've tried to enter an agreed scheduling order. We've tried to do depositions. We've tried to do written discovery. We've tried to do agreed motion for continuance, anything and everything just to try to get this into discovery because we're stuck and we haven't done discovery. And finally, after our scheduling conference, the Stonecoat entities did respond to requests for disclosures, which they had not previously done, and identified a new party. So now we've got an additional new party. And basically, I can give you all the dates and everything, and we can do that if you'd like, but basically, we're at a point in this case where we now have parties in, new parties. We have old parties, but we haven't been able to conduct discovery. All the interrogatories and written discovery that we sent to Stonecoat, they objected to as the discovery period is closed. They quashed our deposition notices based on the fact that discovery was closed, but they will not work with the parties to enter a new scheduling order, which is clearly necessary since additional parties have been added in. A lot of this has gone on with, COVID and scheduling orders changing, and attorneys have really been good, in my experience, at working together to kind of get the ball moving forward. We just can't seem to get that done in this case. There's basic discovery about which is the correct party. I know there's an affidavit. There's still some fact issues that remain as to whether or not they're a correct party, a related party. And we're really just asking for a chance to obtain basic information before we do summary judgments. I don't have any interest in keeping a party in if they're not a proper party. But the problem is we don't have enough discovery at this point to know.
So let me ask this. Well, let me ask. I want to ask you some questions first. So when was you're the plaintiff's attorney, correct?
Yes.
And then when did you sue Mr. Shamoon's client?
January of 2021.
Of 2021. Okay. And then there were additional parties added since then.
The plaintiff added the third parties that are currently in the suit then. Last month when Stonecoat said a new potential party was Stone Fascia Fort Worth. Stonecoat entities will get a little confusing. We went ahead and added that entity. It was recently discovered another potential Stonecoat entity was in play. So now we've added another one. So at this point, Stonecoat has brought up two new defendants that we have no discovery on. We don't have discovery on them.
So what discovery have you sent to Stonecoat?
Requests for production, requests for disclosures, and interrogatories.
And who were the original defendants in the case?
Whitmore was the only original defendant. Whitmore then brought in the subcontractors, and then we brought them in.
And Stonecoat is one of the subcontractors?
Yes, Your Honor.
Okay. All right, response?
Well, Stonecoat, my client, Stonecoat defendant that I'm representing of DFW LLC has no idea who these plaintiffs are. We don't know what services were provided to the plaintiff. We don't know anything about the plaintiff. There's no contract with our company. There's no communication with our company. There's no payments to our company. And we originally were not sued by the plaintiff. The plaintiff sued on June the 20th, 2020. The defendant, Whitmore Construction. Whitmore Construction filed a third-party claim against our client, where when we responded to the third-party claim, we told the entire world, we don't have anything to do with the plaintiff. We never provided any services to the plaintiff. The proper party is Stonecoat of Fort Worth. Just 7 days ago, or was it 11, Steve? 11 days ago, the plaintiff finally sued Stonecoat of Fort Worth. And in fact, there is a contract that we became aware of as a result of another motion for summary judgment filed, where the plaintiff entered into a written contract with Stonecoat of Fort Worth LLC. And so, Judge, my client has spent enough money trying to explain to the plaintiffs, we have no involvement with your company. You've never paid our company a dime. We've never provided any services to your company or anybody affiliated with your company, and they don't dispute that. They don't have any evidence to contradict that.
Mr. Shamoon, let me ask you a question. Does your company have any business dealings with Whitmore?
No.
Oh, okay. Well, what evidence do you have that this is the right Stonecoat, Ms. Schwartz?
Your Honor, honestly, that's the problem, is they have given us the name, and they only disclosed this name after our scheduling conference last month. It has not been out and about. When looking into Stone Coat of Fort Worth, they said their trade name or their actual name is Stone Fascia. That company wasn't even in existence when this work was done. If you go to the Stone Coat of Fort Worth and you Google search it, and you see the owner of Stone Fascia, it actually has a link for Stone Coat, which directs you straight to their website. Stone Coat has a trademark for their name, and Stone Coat of Fort Worth uses the exact same name, the trademark. So it appears there's something, we don't know the interrelationship of these parties. I can tell you that Stone Coat of DFW is very protective of its work and its trademarks and its everything. It's been in litigation with ProCal for, I don't know how long, based on proprietary information. It doesn't seem to make sense that a company in Dallas is going to let another company in Fort Worth use their name, their trademark, and all of that, and not do something about it. So that's a basic problem. I would love, if they're not a party, let them out. I just need to know some basic.
What about this contract that Mr. Shamoon is talking about that says in the contract?
And in the contract, that's where it has the same trademark emblem on it. It's a certain way they do Stone Coat.
I guess where I'm kind of not following is Mr. Shamoon is saying that you have the contract between Whitmore, I guess, and Stone Coat of Fort Worth. Yeah, I think you said, and maybe I misunderstood you, that Stone Coat of Fort Worth did not exist at the time this work was done. Is that what you said, or did I misunderstand?
That's correct. At the time, it was. If I understand correctly, and again, this is kind of speculation because we don't know. Stone Coat of Fort Worth was operating under the name Stone Coat of Fort Worth, using the trademark that Stone Coat of DFW was using. After this incident, Stone Coat of Fort Worth stopped using that name and operating under it and started operating under Stone Fascia. And there are other Stone Coat entities. There's a Stone Coat of North Dallas, there's Stone Coat of Fort Worth, there's Stone Coat of DFW. And my inclination is that they're related somehow. We do know that the plaintiffs were actually taken to Stone Coat of DFW's facility, their manufacturing factory, to show them the product. So they're the ones that actually showed them the product that's all in dispute at this case. So we don't know what was said at that meeting, if they were referred to certain types of product. We just don't know. And that's the problem. We don't know.
Mr. Kane, you're representing Whitmore, is that correct?
No, Your Honor, I'm representing Whitmore's sub that actually paid a Stone Coat entity, and I'm not, we have filed the evidence that I think everybody's referring to. I can show you the pictures that I have if you want me to share my screen. But
yeah, why don't you share screen the contract so I can take a look at this contract that you guys are talking about.
In as much as there is a contract, so to speak, the document that I have with a Stone Coat entity is this quote, and just, you can stop me at any time. And at the bottom here, it does indicate who the quote was prepared by, and indicates the city of Fort Worth. Yes, Your Honor.
Is this the contract, Mr. Shamoon, you were referring to? Is it something else?
It is that very contract, Your Honor, that shows a payment, Stone Coat of Fort Worth. These are not our invoices. This is not our company. We didn't provide any of the services, and we didn't receive any of these so-called check 4210, 4222, and 4239. And in fact, there's an individual, Sid Sagesser. We don't know who he is. So, you know, this fishing expedition, let's just sue all the Stone Coats in America and maybe win a stick, is not how we should be conducting ourselves in the litigation practice, in my opinion.
And is Stone Coat of Fort Worth was just brought into this? Am I understanding that correctly?
11 days ago.
They haven't even been served.
When did you get the copy of this contract, Ms. Schwartz?
We just got this when it was filed in regards to the summary judgment response. We did not have it before then, but it does, as I was discussing earlier, the little emblem at the top, the stone coat. Oh, that's actually a trademark of stone coat of DFW. And so I think at the very least, the plaintiffs have gone to their factory to pick out what they're gonna do. Then they end up, so that's a stone coat. They end up using a stone coat entity that uses the exact same logo. We don't know the relationship between the two stone coat entities at the time. The affidavit now says they have no relationship now, and that's great. I don't need to know what they are doing now. I need to know the relationship that was happening when the work was done and stone fascia wasn't in existence. I'm not asking for the moon from them, just some basic information to sort this out is really all we need. And we probably could have done it on our own with just, exchanging some documents. This has just become a very contentious issue as far as just getting discovery. And it's, as I said before, really holding everything up. I appreciate what he said. I don't want to, to keep in parties that don't belong in here, but I also can't voluntarily let out a party that I can't say I know wasn't involved. I know, I can tell you they definitely weren't involved. I can't tell my clients that in this case.
Well, Judge, I think counsel cannot show this court any due diligence. Counsel just hauled off and filed a lawsuit against Whitmore, which she has a right to do. And then Whitmore sued us, and then we disclosed to everybody we're the wrong person. Nobody has contested our affidavit of our corporate representative attached to our motion for summary judgment. And how is it that a plaintiff does not have the very invoice that Whitmore has showed the court, or that we have showed the contract for Fort Worth?
Who represents Whitmore here? Sir, okay, you need to unmute.
Sorry, is there feedback now? I've got my computer and can everybody hear me okay?
Yeah, everyone can hear you fine.
Okay, sorry. Yeah, I represent Whitmore.
And so who is your company's relationship with? Was it with Stone Coat of Fort Worth or Stone Coat DFW, or do you know?
It was with DK Alliance. So Ari, the plaintiff in this matter, hired us, Whitmore. Whitmore then turned around and hired DK Alliance. DK Alliance then turned around and they hired one of the Stone Coat entities, which it looks like it's potentially Stone Coat of Fort Worth or one of the Stone Coat entities. And then at the end of the project, after plaintiff began experiencing certain issues, there was another contractor that got involved, a third party, and also a defendant, third party defendant, ProCal. They turned around as well. They hired a Stone Coat entity that is either could be the same or could potentially be a different entity, could be under the Stone Coat of DFW umbrella. We're not aware. But part of the discovery that we were trying to conduct, in addition to the documents that we did have, was to depose DK Alliance to determine what individuals did they speak with, who did they do the walk with, who was there, so then we could potentially rule out and find the proper Stone Coat entity if it is not Stone Coat of DFW. Once that got filed, the deposition got quashed, and so that's kind of, we've just been in sort of this circular discovery pattern. So that's why we're requesting.
Who represents DK Alliance? Is that David Kane?
Yes, Your Honor, but I didn't file the motion to quash.
So who did your company do business with? Which Stone Coat entity?
So the check, Your Honor, you saw the shared screen. Everything that I showed, the checks were cashed by an entity, the checks were cashed. The entity on the check is Stone Coat Fort Worth. I can't get the backs of the checks yet. I'm looking for that to get an account number. And so everything that I show is this Stone Coat of Fort Worth. My client, I'll just throw this out there. My client doesn't know which of those, and it doesn't understand who he was dealing with, other than that there was a product, this Stone Coat product, and he does verify that the emblem was used, and he does acknowledge that I think that the whoever was making the selections actually.
You're cutting out. I can't hear you.
I'm sorry.
We can't hear you.
Can you hear me now?
No, barely.
Okay.
Now we can hear you.
Okay. Sorry. That's usually never a problem. So my client does say that the Stone Coat, whoever has the brand, it was a Stone Coat brand that was selected. He is not aware of the distinctions between whether he was dealing with one entity or the other. He made out the checks to who he was instructed to do. Does that help?
That helps. I think that helps. So, Ms. Schwartz, it seems like this is kind of pretty clear.
Your Honor, from everything everyone else has said, I think it's more unclear. We just don't know. I mean, basically, we could get a deposition or two to know the relationship of the parties. As I said, Stone Facial wasn't in existence. There's no entity that was using Stone Coat of Fort Worth legally at this time.
How is that possible if the invoice says Stone Coat of Fort Worth, though?
Well, and Your Honor, I believe that Stone Coat of DFW was also operating Stone Coat of Fort Worth. There's also a Stone Coat of North Dallas. I don't know what that agreement would be.
That is such a fabrication without any basis.
I'm sorry, I did not interrupt your argument.
Well,
Not a
you
fabrication.
didn't mislead the court either.
Sir, Your Honor, that is the simple truth. You even heard Mr. Kane say that his client doesn't even know which entity is which. We know that the plaintiff toured the Stone Coat DFW facility. We know that a Stone Coat entity performed the work. We know the Stone Coat entity was paid. We know that another Stone Coat entity, maybe the same one, came in at the back end. We just don't know which Stone Coat entity is which. And no one's going to allow us, or no one so far has allowed us to do the discovery that we need to make a conclusive determination.
And Judge, after 32 years of practice of law, we don't have a practice here at our law firm to just go sue people and find out if they're the right party. When there's a 202 petition that can be filed, when there's a lawsuit against Whitmore, which the plaintiff filed, that could have sent subpoenas, that could have sent a deposition as a witness to find out, that could have done some type of discovery instead of adding us as a defendant in this case, and then just 11 days ago suing
Sir, if I
for
could actually continue
contract
what I
Stone
was
Coat
saying.
of DFW.
Just
My
okay.
turn.
Ms. Schwartz, go ahead.
Thank you. That's my train of thought, all that. We didn't sue them willy-nilly. The general contractor, Whitmore, brought them in. As happens in construction cases, generally the contractor has a lot more information about the subcontractors than do the people who hired it, so the plaintiff in this case. Honestly, we're just trying to find out who the right entity is. We did have a basis. We know that our plaintiffs walked through this facility. Our plaintiffs thought that the Stone Coat DFW facility was doing the work. That's where they went. That's where they picked up what they were doing. We didn't just sue them out of the air. So there was a point. And now they didn't tell us anything about Stone Facial Fort Worth until last month. And now they want us all just to accept they have nothing to do with it. And my job is to investigate whether or not they do have a relationship, because my clients did go to Stone Coat DFW warehouse and factory to pick out their work. They talked to the people there. I don't know what the people there said or represented. There's too much that I don't know to be able to tell you, Your Honor, that they didn't do it.
I guess my question is that, at least from what I've heard, that the invoice was to Stone Coat Fort Worth, the checks were to Stone Coat Fort Worth. I guess your argument is that because they toured a facility of Stone Coat DFW, do they know that Stone Coat DFW did the work, or there's no cause of action against someone just because you toured their facility?
So their understanding was that's who did the work. They didn't know that there were multiple Stone Coat entities. They went to their facility, they inspected the work, they toured around, they picked out what they wanted, and they were under the assumption that Stone Coat of DFW did it. No one knew of the different Stone Coat entities until they were raised by Mr. Shimon in the motion.
And
So-
Judge, if what counsel had said had any credence, she would have an affidavit signed by a person with knowledge of relevant facts attached to the response for the summary judgment, which she does not.
Saying that my clients toured the facility.
Saying what you
we did
just said.
attach stuff that shows that it appears that these entities are connected, and that's all we want to know. All we want to know is the relationship between the entities, because they waited until last month after we talked at the scheduling conference to say that there's another party. They waited that long. They could have done that when they responded to Whitmore's disclosures in August of 2020, I believe. They didn't do it until now.
Well, wait, let me ask about that. So it's Stonecoat, I thought Stonecoat was only brought in this January.
Stonecoat was
Stonecoat-
brought in by the third party before,
Okay.
and disclosures were sent, and disclosure responses were sent by Stonecoat, and they did not name any other potential third party. They did not
So
name a potential third party until last month.
So Mr. Shamoon, is that true? Did you guys answer discovery a number of months ago and then you didn't disclose the Stonecoat Fort Worth as a potential party?
On March the 24th of this year,
Mhm.
we responded to discovery wherein we disclosed in response to the interrogatories, we are not a proper party in this lawsuit. We had no idea who they contracted with, who they wrote their checks to. We didn't know what services were provided on their job or by who. We didn't know until just recently when the contract with DFW, Stonecoat Fort Worth, was the entity they contracted with. So if she says, well, y'all didn't tell us what entity we contracted with, hell, we didn't know. We just knew we were not the proper party. And when
I'm
we
sorry.
responded to the interrogatories in March, we let them know that.
Your Honor, it's one thing to say I'm not a proper party. That's not what the disclosures require. It requires you to say if there's potential party. And I believe he just said, correct me if I'm wrong, throughout this hearing, that he has said it since the beginning that they're not the proper party and Stonecoat of Fort Worth is the proper party. And now he's saying, oh, he just never knew. It just makes no sense. This is just plain gamesmanship instead of actually doing what we're supposed to be doing, which is moving the ball forward, finding out who did what, and how to try to resolve it. We can't resolve it. We can't even get to mediation at this point because we can't get any discovery done.
Judge, for her to suggest that I wouldn't let her know the proper party's name if I knew it is absolutely absurd. Okay. I mean, if I would have known who the proper party was, I would have let her know the second day we got sued. I let her know, they let us know who the proper party was by showing us within the last few days who the proper party was that they sued 11 days ago, which is Stonecoat of Fort Worth. And
Your Honor,
for them to say that we should have known who the proper party was, how would we have known that?
Your Honor, if I may, at our scheduling conference, the issue of disclosures came up because they brought up the addition of a new party and admitted to this court that they'd known and had not put it in a disclosure response. So that's just disingenuous. That's just completely disingenuous.
I'm supposed to guess
did
who they
what?
are?
Ms. Schwartz, you said that
At our
Mr. Shamoon said that he knew there was another party, but he didn't disclose
Well,
it.
he said in this hearing that he's known forever and he's told everybody forever. Well, that didn't happen. No one knew anything about this until the disclosures came out after our hearing. At the hearing on our scheduling conference, he actually stated that there was another party. And you asked him, had he put that in disclosures? And he said no. And then he turned around and said the disclosures. So I put in interrogatories, I'm not the proper party. I didn't have to disclose it way back then. Discovery ended. They didn't tell us about any other party until last month.
Let me ask something that I'm not sure I'm fully following. So your client who's the plaintiff toured Stonecoat's DFW's facility, but you guys did not directly contract with them. The contract was through
Plaintiffs didn't
DK.
contract with anyone but Whitmore. because these are subcontractors. So Whitmore arranged for Stone Coat DFW to give them a tour around the facility to show them what the product was, to show them what they could do, so that they could pick the product. And they did pick the product. And so that's why DFW is Stone Coat DFW is in. If there are related entities, that would have been something they should have easily disclosed to us. We could have investigated. We could have added new parties in earlier if necessary. Where we're standing right now is, we don't know the interrelationship with the parties. We know that the party they're saying did the work didn't even exist at the time. We know that the same emblems were used. We don't know the relationship between these parties. We don't know if it's kind of a sub, if it's a franchisee agreement. We don't know. We don't know if they use the material. We don't know anything about the relationship because we just found out. And at the same time they disclose the part, they say, oh, but don't conduct any discovery. Just take our word and let us out. And I just don't think that's the way the system is set up.
So let me do this. I understand the frustration here. And I want to understand the frustration on both sides here. Let me do this. I want to be able to get to this summary judgment as soon as possible. I do want to give Ms. Schwartz an opportunity to take a deposition. You can take that either of someone from Stone Coat Fort Worth or from DK. You can, I guess you've sent discovery to DK,
Yes,
correct? And that's how you got the copy of the contract?
Yes, ma'am.
All right, so I think all we need, so is there any, DK, have you given all of your documents about this work over to Ms. Schwartz?
We've given it to Mr. Lipscomb, and I believe I've just started sharing it with Ms. Schwartz, but the answer is the intention was to share it with everybody. So to the extent that we've shared what we had, at least with our direct plaintiff. But I believe through the filings and then some other discussions we've had, if she doesn't have anything, I need to get it to her.
All right, so you're going to be allowed, Ms. Schwartz, to take 1 2-hour deposition of DK or a representative of Stone Coat Fort Worth within the next 30 days. What?
Your Honor, I don't represent Stone Coat.
I know. I understand
Okay.
that. I'm ordering her to take yeah, I understand that. I appreciate that. I'm just saying she has the opportunity. If she wants to reach out from someone from Stone Coat, she can subpoena them or whatever. You need to do this within the next 30 days. You need to, I'm going to order, and you said that, I'm a little confused. So you've, Mr. Kane, you have answered discovery but not given the responses to everyone, or how do some people know about this?
I served the answers on, I didn't receive direct discovery from the plaintiff, I don't believe. I'll go back and check. I believe I received direct discovery from Whitmore, and that is what I supplied the responses to.
Okay. I want you to share that with all parties.
I served it through the systems, but
Okay. So never mind about that. So Ms. Schwartz, then you have 30 days. You're allowed to take the deposition of one of these two entities, the corporate rep, and then you have and if you need to compel, you haven't sent direct discovery directly to DK then.
I thought I had, because I thought we sent it to all parties. I haven't looked at theirs specifically, but I can check.
So if you need to compel on them, because you don't think they've produced everything, you need to compel on that.
Okay.
But we'll go ahead and reset this on September. How does September 13th sound, or September 10th?
Either one, Your Honor.
Mr.
The
Shamoon,
10th is better for us, Your Honor.
September 10th at
Yes, sir.
10 o'clock.
Yes, sir.
So to summarize, Ms. Schwartz, I want you to get me an order that says that you're allowed to take the deposition of one of those two entities for 2 hours, and that the deposition has been reset to September 10th at 10 o'clock, or not the deposition, the summary judgment has been reset to September 10th at 10 o'clock.
Thank you, Your Honor.
All right, guys, thank you so
Well,
much.
Next
Hang
Monday.
on a minute. We also had a motion for summary judgment, no evidence in traditional against Whitmore. Will we reset that at the same time too?
Reset that at the same time. And as the attorney for Whitmore, is there any additional discovery you would need besides what we just ordered?
No, Your Honor. I do want to add, if it's Stonecoat of Fort Worth, who was just recently sued, that we can't locate, that's sort of part of it. If the limitation is specific to only Stonecoat of Fort Worth that we can't locate, I just want to make sure that we don't have to come back and say, well, it's Stonecoat of North Dallas or Stonecoat of DFW or whoever it is. I don't know who Ms. Schwartz is going to want to take the deposition of, DK or not, but just as a point of clarity, Stonecoat of Fort Worth, kind of part of the reason why I think we're here is that we can't locate them in the Texas Secretary of State, which has added to the confusion. So if it can only be someone from Stonecoat of Fort Worth, or DK, I guess that pretty much only means DK at this point because we can't locate Stonecoat of Fort Worth. And we
Okay,
definitely, I'm sure,
I
can't
forgot
do that in
that.
30 days. Yeah. Because that's sort of part of what the discovery is that, the Stonecoat of Fort Worth, yes, we agree that it's on the, alleged contract, the invoice, the back and forth, and we can see the checks. But that's sort of part of the issue is that when you try to find Stonecoat of Fort Worth, we can't find, there's no need to get back into this, but I just wanted to make that point of clarification or to ask you to make that point of clarification. I don't know if Ms. Schwartz is just going to take DK, then it's kind of a moot point. We'll just do that within the next 30 days and hopefully can, just move on from this. But
Can I make a recommendation? I don't
Sure.
want to be didactic with all the lawyers here, but there was a name I saw on the invoice, Seth or someone.
Sit-
Maybe I would suggest that it might be appropriate to serve him.
Or to take his deposition.
Yes.
We have filed suit against them. They just simply have not been served yet. But again, there's some confusion because that's not Stonecoat of Fort Worth, that's Stone Fascia, which wasn't in existence until after the work was done. So there's just so much confusion in the names. But as long as I could take someone from DFW or DK, I think we could get it done. And I'm
And you
willing to
could,
work with
and you
Garrison.
can also take this guy Sidge, whatever his name
Okay.
was.
And
you
I'm
could take his
completely willing to
deposition.
work with Garrison on who to depose, and because I know we both have issues with this.
All right, guys, thank you so much.
Thank you, Your
Your
Honor.
Honor.
And when you do the order, Ms. Schwartz, make sure you share it with Mr. Shamoon. Make sure that you include on the beginning of the order that this hearing was held on August 2nd, 2021, not on this date.
Okay.
Email my court coordinator and e-file it as well.
And let me close with this. My client does not have to sit for a deposition and spend another $20,000.
No, she does, at this point, does not have to sit.
Thank you, Judge. Bye-bye.
You can join if you want to.
Okay, bye-bye. Have a
All
nice
right, bye, guys.
Thank you, Your Honor.
Thank you.